The Law Factor with advocate Clarence Arenas Gandawa.
Good day to you all. Let's begin with the workplace of justice. Justice is not only argued in courts, it is lived in workplaces. Every contract signed, every wage earned, every dismissal delivered is a test of dignity. When workers are silenced, when wages are withheld, when dismissals are arbitrary, justice is denied at the very site of survival. Labor rights are not privileges, they are protections. Employment law is not paperwork, it is the architecture of dignity at work. Now to the fog of contracts, employment versus exploitation. Too many workers sign contracts they cannot read. Too many employers improvise rules they cannot enforce. And too many dismissals happen without process. Employment justice means every worker knows what they are entitled to, how they can be dismissed, where they can appeal, what protections the law provides, because when contracts are vague, exploitation thrives. And to a case study, the dismissal without due process. A factory worker in Matapa was dismissed for misconduct. No hearing was held, no warning was given, no union was consulted. The worker lost her income overnight. This was not discipline, it was dispossession, and it happens more often than we admit. Then to judicial responsibility. Courts as guardians of work. Labor courts must do more than arbitrate, they must defend dignity. When a worker is dismissed without hearing, the court must intervene. When wages are withheld, the court must enforce payment. When contracts are ambiguous, the court must clarify. Because justice is not about rulings, it is about protecting livelihoods. Let's talk Parliament. Legislating with precision. Labor laws must be written with discipline. Fair dismissal must be defined. Reasonable wages must be measurable. Worker protections must be enforceable. Ambiguity breeds abuse. Abuse breeds despair. Parliament must legislate with clarity, not compromise. Now we speak to the public. Labor literacy is civic power. Citizens must know not just their rights, but how to claim them. Radios, unions, schools, and churches must teach how to read an employment contract, how to file a grievance, how to demand fair wages, how to appeal dismissals. Because silence is not ignorance, it is design, and we must redesign. We move to Eswatini in focus and the continental mirror. In Eswatini, many workers still rely on verbal contracts, leaving them vulnerable to sudden dismissal. Labor courts are under-resourced and unions struggle to enforce protections. In Botswana, labor dispute resolution centers provide accessible mediation. In South Africa, labor law enforces hearings before dismissal. Eswatini must not lag, it must lead. Work with dignity is not a privilege, it is a right. Employment is not charity, it is a contract. And contracts must protect dignity. When workers are dismissed without hearing, when wages are withheld without cause, justice is denied at the very site of survival. Labor rights are the shield of dignity. Don't just work, know your rights. Don't just earn, demand fairness. Justice must live in every contract, every wage, every dismissal. The law moves forward, you must move with it. See you next Thursday. The work continues.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.